19 meeting of Henderson County Fiscal Court. I'm glad you're with us today. As always, we will begin with an invocation, and Father Larry McBride from Holy Name Church is with us. Please stand as Father McBride leads us in prayer.
And let us pray. Our good and gracious God, we are thankful for all your many gifts and blessings. We ask you to be with us today to guide us with your wisdom. Help the county to always make good decisions for all of its people, that we may seek the best for all of them. We ask you to bless farmers during this season as they bring in their crops, that they may have a fruitful and productive. We bless all of those who are in the midst of the heat, who work in the heat, or for whatever reason do not have protection from the heat. Bless them and take care of them. Help us to be your people in all that we do, and bless our decisions and our decision making. And we ask all of this through Christ our Lord. Amen.
Please join me in the pledge.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Father McBride. Appreciate you visiting always. Thank you. Mr. Clerk, would you please call the roll?
Magistrate Southern.
Here.
Magistrate Moran.
Here.
Magistrate McCollum.
Here.
Magistrate Berry. Here. And Magistrate Putman is out today.
Lady and gentlemen, you have before you the minutes of the September 24th, 2019 Fiscal Court meeting. After a period of review, I entertain a motion to approve those.
I move to accept.
We have a motion and a second. Any clarifications, corrections, or additions? All those in favor of accepting the minutes signify by saying aye.
Aye.
Any opposed? Okay, we have some special guests with us today, and many of you may know that Pittsburgh Tank and Tower is now a century old, and perhaps one of the most vital and engaged corporate citizens of Henderson County. And we could not let that milestone pass without recognizing the Johnston family. We have with us members, and before we read the proclamation that we're going to give you, any thoughts or comments about your incredible run in history here?
Well, Judge, I just say thank you, thank this community. It has been an exciting year. The things we've done with our employees, with the community, the engagement, the book Men of Steel, and the work that Chuck did to protect and preserve the history that has been, as he says, very rich. He said we gave him a lot to write and work with,
Yeah.
and we did. But it's just been an honor, and we look forward to continuing being part of the community and continue some growth. Chris, you want to add to that? Okay. Said enough for both of us.
So at least third generation, fourth generation now?
Actually, fifth generation.
That's incredible. Well, if you wouldn't mind coming up front here. First, we'll read the proclamation.
Whereas Pittsburgh Tank and Tower Group is currently celebrating its 100th year in operation, and whereas in that century of service, Pittsburgh Tank and Tower Group and its founding family, the Johnstons, have been models of hard work, unmatched skill, staff development, and community engagement, and whereas from its humble beginnings, Pittsburgh Tank and Tower Group has grown into a multifaceted company that employs hundreds and boasts an international clientele, and whereas the members of the Henderson County Fiscal Court are so impressed with what the Johnston family has accomplished, and so thankful the company has chosen to keep their operations headquartered here, that we could not let Pittsburgh Tank and Tower Group's 100 years of excellence go unnoticed, unrecognized. Now, therefore, I, Brad Schneider, Henderson County Judge Executive, join with the Henderson County Fiscal Court in honoring Pittsburgh Tank and Tower Group and declaring 2019 as Pittsburgh Tank and Tower Group Year.
Right, ready? Okay.
Amen.
Thank you again, Ben and Chris. 100 more years we wish for you. We also have a proclamation honoring Kentucky Extension Homemakers Week, and I think we have members of their organization with us. If you want to come up to the podium, and if you'd like to make any comments before we read the proclamation, that'd be terrific. Please introduce yourself.
Hi, I'm Marilyn Watson. I'm the Henderson County Homemakers President, and we are a well-kept secret organization, I do believe. We're seeking new members, and with it, we are really well noted in the state for all of our volunteerism that we do through all civic-minded, church, statewide organizations that we support with individuals that they do. So,
Thank you for all that you do. I know trying to help you relinquish that title as best kept secret, trying to get the word out. But we're going to read a proclamation in your honor. And if you want to come up front with us. You want anybody to take pictures of you? The proclamation first.
Whereas the Kentucky Extension Homemakers Association Incorporated has more than 13,900 members in more than 800 clubs throughout the Commonwealth, and whereas since its formation in 1932, the Kentucky Extension Homemakers Association has strengthened individuals, families, and communities through education, leadership development, and community volunteer service, and has focused on improving the quality of life for families and communities. And whereas this organization over the years has continued to endeavor to strengthen, develop, coordinate, and extend adult education in family and consumer sciences in cooperation with the Cooperative Extension Service of the United States Department of Agriculture and the University of Kentucky. Now, therefore, I, Brad Schneider, by virtue of the authority vested in me as County Judge Executive of the County of Henderson, Kentucky, do hereby proclaim the week of October 13th through the 19th as Kentucky Extension Homemakers Week in Henderson County.
Right, ready? Okay. I'll send it.
You're welcome. Thank you, Marilyn. You're welcome, Marilyn.
I didn't know I had to make a speech. I might
Yes,
have
yes.
thought of something. You know all about it.
Yeah, I do.
I know it.
Thank you again. Ladies and gentlemen, you have in your packet a zoning ordinance that we have needed to put into place for some time now, and we're finally getting around to it. As you may know, solar companies that would potentially put up solar farms to help provide more power, renewable power, to the energy mix at both Big Rivers and HMP&L have been in Henderson County for a couple months now, scouting locations and seemingly intent on locating business here. They're doing this in response to an RFP that was put out by Big Rivers and Hempel to increase the mix of renewables they have in their energy portfolio. But we did not have an ordinance controlling the zoning of those solar farms and taking into account some things we knew that both neighbors of these solar farms and the county would want to make sure they adhere to. Our Planning Commission Executive Director, Brian Bishop, is here. He has worked with both the City-County Cooperative Group and our neighbors in Davis County to craft a zoning ordinance that would help provide some guidelines for these solar farms, and I'll turn it over to Brian to add to that if you like.
No, the judge summed it up very well. Solar farms are on the horizon. I think it would be best for us to be prepared as quickly as possible. I will do my best to answer any questions about this zoning ordinance update that you may have.
Can you talk a little bit about utilizing Davis County as a model?
Yeah, we use Davis County as our template. They had recently updated their zoning ordinance. I believe it was in February or March of this year. I contacted Brian Howard, who's a good friend and a good confidant. They had gone through a lot of research. I compared what they had with some of the ordinances that I had collected. A lot of the ordinances are very similar. You're looking at things like lighting, setback, distances from roads. One thing that we thought was very important for us, because I know a lot of us have a bad taste in our mouth from coal mining in the past, is that a surety bond will be posted so that the company cannot just simply walk away from this investment. So that's one thing that we really wanted to have in the ordinance, that if for some reason the companies do not last, we would have the means to remove the panels once they were complete with their project.
There's also contemplated in this ordinance things like screening.
There is. If you look at Section D, I believe it is, it will be screened by 8-foot tall fence with double rows of staggered pine trees planted on 15-foot on center from any public right-of-way or adjacent residence. So we want the property owner to maximize their property, but we also want to protect the neighbors in the process.
Similar ordinance, the exact same ordinances will be considered by the city.
It is. The city's making a few tweaks because they have some smaller solar panels that could be in the city in different districts. But for the section that we will be dealing with in the county, I would believe they are largely the same. And honestly, the solar farms most likely are not going to be prevalent in the city just because they don't have the space.
We'll be obviously showing the Planning Commission this language, but both Brian and the City-County Cooperative Group felt time was of the essence.
Yes, sir.
And eventually, this ordinance would have come back for us to vote anyway, so we thought it'd be most expedient to bring the language right to both the City Commission and Fiscal Court. Mr. Gold has reviewed the ordinance. Any thoughts, Mr. Gold?
Well, this is a resolution. The way a text amendment works is that the text amendment can originate either with the Planning Commission or the Fiscal Court. As the judge alluded to, by originating it with the Fiscal Court, it gets it moving a little quicker. And what this does is it starts the process of, it refers it to the Planning Commission to have a hearing.
Correct.
The law requires that there be a public hearing on this so the public have an opportunity to weigh in. So this is the starting point for this text origination of that zoning amendment. So there's still more to do. It's not as simple as just passing an ordinance, but this essentially starts the process and puts it in the Planning Commission's
Correct.
court.
As Mr. Gold said, we will hold a public hearing for the text to be reviewed. Any potential property owner or landowner or even a solar panel operator could come in and give their input to what we have proposed. That will be held at the first Tuesday in November at the Planning Commission's regular meeting. So you're welcome to attend.
Any other questions?
Yeah, Brian, does this limit the farmer, this half acre?
You're talking about the for the SE2, the
Yes.
smaller ones?
Right.
From what we've ascertained, I don't think that they would coexist with each other. The way the panels would maximize the property, there wouldn't be much room for farming. Theoretically, they could do both, but I would think the space would be very tight and not conducive.
But it is limiting. A farmer can't put in a larger panel if he wanted to be self-sufficient, had a couple of homes that he was wanting to.
Well, that would probably be the level 1. Do you want level 1 or level 2?
I don't know.
Well, level 1 was probably the one that's more suited for personal use because that's where it talks about mounted on code compliant structures. But if you level 2 or something that a farmer could do as well. The thing that we're really wanting to regulate are the level 3s because that's where you're going to see hundreds and thousands of acres. But it's important to have provisions for smaller panels as well. Am I answering your question right?
I guess you are. So why do you need to take care of the smaller panels?
Well, the smaller panels actually could, like for example, if Mr. Gold had a 1 acre farm or 1 acre parcel and he wanted to come in and load his property up with solar panels, there's still things to be considered. 1, they're still structures. They still have to meet setbacks. 2, they could be attached to the building and therefore could possibly require a building permit because they would be adding loads and stress to existing buildings.
Okay, I got a 300-acre farm and I want to put a couple acres out there, what does that do to me?
That would probably drop you into the level 2 solar system.
So
Which,
half
if you look
acre.
at that, it's in the agricultural zone. You could have 1.5 acre in size and shall require a building permit from the county codes department, and then they would have a site plan to make sure that they meet all the setback requirements.
Why should you limit me?
Basically, we're getting to, once you get above the 1/2 acre, you're getting to more of a commercial use, and then that's where we're going to look at lighting, we're going to look at setbacks, we're going to look at drainage, because 300 acres of solar panels are going to produce a lot more drainage than 300 acres of farm, because the water will run off those panels much faster than they would farmland. So it's more of a commercial use at that point.
Even if I'm using it on my farm?
That is up to the property owner. The point is the size, once you go over the 1/2 acre, this ordinance treats that more of a commercial use.
And what can I do if I want to go to more than 1/2 acre?
You would move into the level 3, that's a site plan that comes to the full plan commission instead of just the county codes. Basically, the premise is it depends on who reviews it, just the county codes level or if it reaches to the plan commission level. It's no different than a small business. Say, for example, if someone had a small business in their on their own farm, they wanted a conditional use for an accessory building or a, what's the word I'm looking for, Steve, help me out, home occupation. That's a more smaller level review that would go to the Board of Zoning Adjustment or even Randy at the Codes Department. Once you get above that certain level, a certain threshold, that's when the Plan Commission becomes involved.
And it says on it, so I got to take it down?
Yes, sir?
I mean, that's how I keep my cattle in.
I guess the use would not be cattle and solar panels together.
But you're
getting
talking
into
about, that's a requirement on level 3,
level 3.
Right.
not level 1 or 2.
But whatever, we're putting restrictions on people that I'm just not sure that I'm pleased with as a farmer. And
Well, what we're talking about, and if you don't mind,
Yeah.
level 3 is when we're getting an industrial size.
Correct.
solar
That's
panel,
most
right?
likely what we're going to be dealing with.
If you are getting into the industrial solar business, I think you have to completely rethink the purpose of your farm ground, including cattle, that it's going to be used for this purpose, solar purpose.
okay, so I use goats because they can help keep the grass clean.
Well, you can pen up the goats, but you just can't put the barbed wire around your solar field, or not your solar field, but the company that has leased from you to get that solar field.
But I want to do it myself. I'm not doing it for anybody else. I'm doing it as a farmer for my own production of energy.
I think we're talking about two different levels of
Yeah.
solar panels. If you're doing it for personal use, that's more likely what we intended to be a level 2 solar energy system is what they're called. A level 3 is what we're really trying to prepare for, is with the large commercial producers of electricity via the solar panels.
And you're limiting the number of lights and different things like that too?
Yes, just like we would in any other business. Everything would be night sky friendly, so you're not disturbing your neighbors. The purpose of this is to protect the property owner and maximize their property, but then protect the adjacent property owners. Because, for example, say you have 300 acres of solar panels, I don't think Mr. Barry, your neighbor, would like to have lighting out there all night, disrupting his property value and his privacy. It's the entire intent of zoning. Maximize one property owner's value, protecting the others.
Any other questions?
When you're talking about bonding,
Yes, sir.
how do we determine, most of these solar companies are looking at a 20 or 30-year plan.
Correct.
So how do we determine what it's going to cost to clean that up 30 years from now?
We would have to try to work that into the calculation. That's something we do like with subdivisions. There's a base amount that it costs today, and then we add roughly 30%. So that's something we would have to try to calculate in.
And Brian, this text amendment does talk about 1% of the,
Estimated cost of the project.
right, and would that be obtained through when they get their building permits?
Correct.
Okay.
A building permit would not be issued until that bond was secured.
Would it be considerate to put something in about the bonding? I mean, the problem we had with the coal company was the coal company owned the bonding company, and they all went bankrupt. So, I mean, just to have a consideration, I mean, to me, it was a fraud.
Agreed, yeah, and that's something.
We had nothing we could do to change it, but they had the same board members on the bonding company as they did on the. I mean, it was just a shell game.
Oh, absolutely. And that's the thing that's the one thing that will be our process to do is make sure that the bonding companies are legit bonding companies and that there's not any shenanigans, so to speak.
But you don't have any language that allows you to do that, I don't think.
I think that would be up to the staff's discretion, is my understanding. That was our intent.
There's also, we've seen some draft agreements, I think, between farmers and these solar companies, and the ones we've seen included bonds for the private landowners
Correct.
as well.
Far more and above than what we're requiring.
Again, these solar companies are doing this all over the country now because of the same request from power generators for a greater mix of renewable energy in their portfolio. So this is going on everywhere. And the companies are beginning to learn what it's going to take to get these facilities established. So I'm confident there are a couple levels of protection, both for the landowner and the county. Don't you think, to Magistrate McCollum's point, it might be good to have language that indicates that the surety bond shall be from a third-party bonding company,
No, absolutely.
not under the ownership or control of the solar
No,
company?
that's
Something
And
Not a
something in
problem.
the language that
Right.
says that you all have to approve it, or somebody, I mean,
Yeah.
where you
The-
go out
I-
and get a what's the companies that do the referencing of companies, the rank us, like we're trying to get our bonding up,
like Moody's and
Moody's, right.
Yeah, no, that's not a problem at all. I think, to me, it was just implied that staff would do that.
I think
But
it makes sense to-
there's no problem with that.
You could put something in there that planning commission staff would have the duty and ability to determine the sufficiency of the bond and the bonding company.
Okay.
I mean,
No, not a problem.
I think that's easy enough, and that's when the public hearing is held on that. That's definitely something that
Can
hopefully
be brought forth.
you'll add in
Yep.
before
not
it
a
comes
problem.
back to us.
Not a problem.
So based on those suggested changes, I'd like to have any other questions?
On the third level,
Hmm?
if I'm a certain distance from my property line, can I put up a chain link fence? I mean, I don't want people in my solar panels. I don't.
Yeah,
want-
absolutely. I would imagine that the,
How far do you have to be away from the property
I
line?
thought, if I double check, I believe we had whatever was in the zone that they were in. So, for example, if it was an ag zone, 10 foot would be your setback.
Oh, okay, well, that's no big deal.
Yeah.
But that's, I mean, I've got a cell tower, and it's got,
Yeah. And that's the thing, is I would imagine the property, not the owner, but the company that's going to lease the property is going to want far more and above than what we're requiring just to protect their own investment, because they're not going to want anybody out there messing with their panels to the fencing.
okay. Now, on the lighting, if I have a barn,
Mhm.
I normally put a night light out by it. If I've got solar panels that's got the battery storage areas and that kind of stuff, I'm going to want a night light out there. Am I not allowed to do that?
No, that's not. Basically, there's a specific sentence in there that says lighting required by state and federal regulations. What we were mainly referring to is like big, huge spotlights that would be out disturbing and interrupting the value of another property owner.
Okay, but there are people that are going to complain about any kind of light.
True. I think that's when common sense is going to have to come into play. Good.
Any other
Thanks, Haz.
questions? I'll have the clerk read the resolution.
Resolution originating a text amendment pursuant to KRS 100.211 to add a new article and/or section to the County of Henderson Code of Ordinances to be codified in Appendix A, zoning regarding solar energy systems. Whereas the Kentucky Revised Statute, Chapter 100, provides for the adoption of zoning texts and maps as well as providing for amendments, and whereas the County of Henderson and the Henderson City County Planning Commission have recognized the need for zoning regulations that promote public health, safety, morals, and general welfare of the community, and facilitate orderly and harmonious development and the visual character of the community by enacting and amending the Henderson County Code of Ordinances, Appendix A, zoning, also known as the 2015 Final Ordinance Number 030415. And whereas the Henderson Fiscal Court deems it in the best interest of Henderson County to originate and propose a text amendment to the Henderson County Code of Ordinances, Appendix A, zoning, pursuant to KRS 100.211 by adding a new article and/or section regarding the regulation of solar energy systems. Now therefore be it resolved that the Henderson County Fiscal Court hereby originates and proposes an amendment to the text of the Henderson County Code of Ordinances, Appendix A, zoning. The proposed amendment is set forth in Exhibit A, attached here to. This amendment is hereby referred to the Henderson City County Planning Commission as required by KRS 100.211. The Henderson City County Planning Commission shall hold at least one public hearing after proper notice and make a recommendation back to the Henderson County Fiscal Court within 60 days of the date of receipt of the proposed text amendment.
Any other questions? All those in favor signify by saying aye.
Aye.
We
Need a motion.
motion.
Sorry about that.
I so moved.
Got a motion?
Second.
And a second. Now, my apologies. Any other questions? All those in favor signify by saying aye.
Aye.
Any opposed?
Abstain.
Motion passes. Moving on, we have a county personnel resolution, and I'll defer to Mr. Gold to brief us. Any additional
Absolutely.
comments?
Absolutely, Judge. And this is a little unique. As I mentioned at our last fiscal court meeting, we did have a resignation in our office, which actually led to a really interesting opportunity for the county and for our office and for the jail. The jailer earlier in the year put out for bids the jail phone contract, which is something that hadn't been up for bid for quite a while. The incumbent bidder, Securus, was the successful bidder that was chosen there, and part of their bid, they included a site administrator, that they were going to fund a full-time person to basically handle open records requests and subpoenas and whatnot that come along with the jail phone calls, which the jail does receive some. Jailer Brady at that time reached out to me and indicated that she preferred dealing with the county attorney's office on open records requests and subpoena compliance and things like that, and that there was going to be this money there, and she would prefer having an assistant county attorney to be that site administrator. And at that point, we didn't have anybody in the office that was wanting to, transition from full-time from part-time to full-time. With Don Thompson's resignation recently, that gave us an opportunity to go out and try to seek that. As many of you all know, the jailer and I work very closely quite a bit, just because there are a lot of employees out there and there's a lot of litigation that comes from inmates. And she saw value to not only being able to contact me about those things, but having another assistant county attorney that was also very involved in what went on out at the jail. So what she proposed, and what I think makes a lot of sense, and that's what we're proposing today, is that when Securus, who also likes this deal because they're not paying a full-time employee, they're just paying a part-time employee, when Securus gives them money to hire a part-time person, that she essentially go to the treasurer, flow that money through the treasurer's office to fund supplement to an assistant county attorney's salary to be that site administrator. So it's a flow through from Securus to the jail, to the treasurer, to the county attorney's office. So I know it's kind of a lot of dominoes falling there, but what it is the assistant county attorney will be paid primarily by the Prosecutor's Advisory Council from the state. So that's all state money and state health insurance and retirement for that amount. And then Securus will be paying the salary supplement and all fringe benefits that go along with that, including pension. So putting those together, we'll be able to make a full-time position for the county attorney's office. And the individual that we've reached out to and sought to hire is James Robert Norris. Bobby Norris is an attorney at Trimble, Lindsay, and Shea. He's been in the practice of law for 21 years, and He was actually an assistant Barron County attorney for 10 years. He came out of law school, worked with Gross Lindsay at Trimble, Lindsay and Shea for a couple of years, went home to Barron County, was an assistant county attorney there for 10 years, and then came back to Trimble, Lindsay and Shea, has been there for the last several years. And we feel very lucky to have Bobby joining our office. He brings a very robust and diverse practice of law to our office, and I love the idea of being able to get a seasoned attorney, not somebody straight out of law school, to assist with this. So I think it's a win-win for the jail, for the county attorney's office, and even for Securus. So I think it makes a lot of sense, and that's the resolution that you have before you.
Steve, so he'll be part-time on the KERS and part on the CERS?
Yes, sir.
Okay. And I'd make a motion well, go ahead and read the resolution now.
Go ahead and read the resolution. Any other questions before we do that? Can you read the resolution, please?
A resolution approving, wrong one. Thank you. A resolution regarding personnel actions in the Henderson County Attorney's Office. Whereas the Henderson County Attorney's Office experienced the resignation of a part-time assistant county attorney who accepted employment with a local law firm. Whereas the jailer has contracted with Securus Technologies, Securus, to provide telephone services at Henderson County Detention Center, and the master service agreement provides for the funding of a site administrator, including salary and benefits, by Securus for Securus-related matters. Whereas the jailer has proposed to transfer the contract funds to the county attorney to allow the county attorney to supplement the salary of a part-time assistant county attorney, and for said assistant county attorney to perform the functions of the site administrator. Whereas the fiscal court deems it in the best interest of Henderson County to maintain adequate staffing levels in the Henderson County Attorney's Office. Whereas pursuant to KRS 67.7107, the approval of the fiscal court is necessary for the appointment of county employees, and pursuant to KRS 64.530, the fiscal court must fix the reasonable compensation of every county officer and employee except those named in KRS 64.535. Now therefore be it resolved by the fiscal court, County of Henderson, Kentucky, as follows. 1. Pursuant to KRS 67.7101 and KRS 64.530, the county judge executive and the Henderson fiscal court hereby approves the county attorney's appointment of James Robert Norris as an assistant county attorney, and fixes his reasonable compensation at the sum of $25,000 per year effective October 16, 2019. 2. Upon receipt of the funding for the site administrator position, the jailer shall take the appropriate steps to effectuate the transfer of said funds, including cost of benefits, to the county attorney's budget.
Entertain a motion to accept that.
So moved.
We have a motion and a second. Any other questions? I do think it's a creative way to bring on again, more experienced attorney, and I appreciate the jailer working with us on that. We'll come up with a good solution.
Steve, he'll be used for other things, just
Yes,
within the
he'll be
office.
receiving, actually, the majority of his salary will be for prosecution, which comes from the state. That's about, I went to law school because I don't like math, but a little more than half from the state, and then the remainder from the county. So he'll be dividing his time between the two. And he'll be available for other things as well. So you'll probably see him at some fiscal court meetings or some other things as well.
Any other questions? We have a motion and a second. All those in favor signify by saying aye.
Aye.
Any opposed? Motion carries. I will defer back to Mr. Gold to talk about the next item on the agenda, which is a lease agreement worked out with Field and Main Bank regarding the grade-all that the road department hopes to acquire. And in initial documents traded back and forth between the county and Field and Main Bank, which we chose to do business with after a survey of other banks in the community as far as interest rates and things like that. Mr. Gold's office had an objection with some of the language, and with that, I'll turn it over to you, Steve.
Well, we're good now. That's the long story. And I'll probably defer to Kyle Evans as well, who kind of spearheaded this project for our office. Essentially, there's a short-term borrowing act under the law that says that the county can't finance something on a short-term basis. It's not like you would at your house go take out a loan or something like that. You can't do a mortgage or anything. That's specifically prohibited. We can only borrow by bonding, essentially. And so CAECO has a leasing trust, and we've dealt with them before where it's kind of strange. You actually lease money from them, but it's a way of dealing with that, and it is a creative way of doing it. Every time we deal with local banks, they're not used to this. They're used to promissory notes and traditional financing, and they refer to people as the borrower and themselves as the lender. And so initially when some of these documents came to us from Field and Main, they had some of that language in there that sounded like a financing and was, talked about lender and borrower and things like that. So Kyle got with the folks from Field and Main, worked with them and got that straightened out. So everything should be in good shape at this point. Kyle, is there anything you'd like to add? Okay. So everything is good to go. Essentially what this is leasing this Gradall from them, but we get possession and Kyle, you want to talk more about the structure? We get possession and even title at the time of the delivery of the Gradall, and the payments do get credited toward the eventual purchase should the purchase be opted.
That's correct. This is a lease agreement that does have the option to purchase at the end, and all the payments that we make towards principal are counted. So it's at the end of this, we give them notice, and it is our Gradall to keep. During such time, we do keep title, possession, have exclusive use. All those terms are governed by that lease agreement that I'm sure you have before you, that we worked with Field and Main to get those terms, and everybody signed off late last week that those terms were acceptable to everybody once we had to sit down and get rid of the debtor and the borrower and those type of things Steve talked about. So,
and as a matter of fact, the resolution specifically states that the judge executive is authorized to provide the lessor of the intention of the fiscal court to exercise that option to purchase. So we're leasing and going to go ahead and tell them, yeah, we want to purchase it at the end.
I don't think we'd intend to pay that many and not keep it at the end. Does anybody have any questions about that lease agreement in particular? It is annually renewable, so if the fiscal court did not appropriate funds or fell upon hard times for any reason, that is what makes it a lease. We could back out, and Field and Main would have a Gradall to take over.
It is not a true legal fiction, but it's pretty darn close to it. It is a financing, but not, as Kyle said, the county could choose not to continue it next year, but at that point we don't have the Gradall and we lose all that we've paid
And
for.
that's the major difference here. Instead of a loan where we would own the Gradall and have to make the payments, this is a lease where the bank owns the Gradall, leases it to us. We could walk away and they have a Gradall that they can do whatever they want with. And that meets the letter of the law.
Yes.
And it is renewable annually, so if,
Right.
as long as we appropriate and we make those payments, we'll
And
continue to keep
we
it.
have done this previously. We did this with, was it another Gradall in 2016?
We did the same type of agreement with Field and Main. That was the first one that kind of spearheaded this.
But it is always a very unusual structure, so we always want to make sure everybody understands what it is as we go into it.
At our last educational program, CAECO, some of their guys gave a history of why we do this. It was very educational. It goes back to the Civil War. After the Civil War, a lot of people came into Kentucky, took over government, and they printed a lot of money, and Kentucky basically was bankrupt. And then we did our new Constitution, in 1892, I think, and it basically prohibited any kind of things like regular borrowing the county, so you couldn't go do what was done previously. And it has made Kentucky, unfortunately, it made it where to get a building for a school, you had to have a election. I mean, it's created some really terrible things, and this is one of them. So, but this is, I'm for this. I don't, not good, but the history on what and how we got here is incredible. And it's one of the reasons Kentucky has poor school systems is because of what we've had. You know, we've gone around in runs on this now with the bonding and that kind of stuff. But it was a really good educational program to tell us why. Because I did, even as being county attorney, I knew we did these crazy things, but I didn't know the history behind it and why we do it. But it's our Constitution that requires it. I
can always count on Magistrate McCollum to link any deal to Reconstruction if he can do that. But anybody else have any questions about this?
So I thought I understood this before you talked.
Lawyers are good at confusing people. It's some of what we do.
So this is, we can opt out next year, give them the grade all, and walk away?
Pursuant to the terms of that agreement, we could walk away. If the, let's say the fiscal court did not budget appropriate funds for next budget year, we would give Field and Main notice, and then we would have to make a arrangement or drop it off at wherever they tell us to. So there are terms in there governing what would happen in the event of a non-appropriation or us giving that notice, those types of things. So
they would strongly prefer us not to do that, though, because I don't think they want the grade all back necessarily.
Well,
however, that the terms of this agreement do, that's what it would be. They would
Yes.
get it back if we decided not to do it. And title would be transferred back to the bank.
What we're paying, though, is that grade all's going to be worth more money than what we owe on it.
Right.
So we're going to be crazy not to continue.
Well, and I agree, but I've just never seen a lease where you can just walk away from it.
Oh, it's
Well,
this structure specifically to deal with the was it the Short-Term Borrowing Act? So it's nobody would do this or see this in their houses or at home, you know,
Right.
but just because this isn't, that act isn't something that individuals or even companies have to deal with. This is something that is peculiar to Kentucky County.
Except in many cases, it's very similar to a rent-to-own
Yes.
deal, like with furniture or TVs.
Right.
Although this
Yeah.
is not at the, not at the interest and the
Right.
upgraded price that it would take to do that.
Better
It's-
deal.
it's-
But the structure is similar.
Yes, yes it is.
So,
and we worked well with Field and Main in 2016. We made some changes this year to even make it, I think, a little bit better. We've included all exhibits. There's nothing else. The financing statement was one of their things. I included that exhibit as Exhibit D so everybody could put their eyes on. There should be nothing else other than this lease agreement to enter into. So it should be a all-in-one package there.
and the reason we didn't go straight through Keiko's leasing trust is we found a better deal locally. The interest was lower locally, so that's one of the reasons.
Bill, we do need grade all.
Yes. Yes, we do.
Any other questions of Mr. Gold or Mr. Evans? Okay, I'll have the clerk read the resolution. Is everybody amenable to reading the summary at the top, or would you like him to read the whole thing?
I've read it also.
Summary's good.
Summaries.
We read the summary?
A resolution approving the lease of equipment for use by the road department and authorizing the execution of documents related to such lease.
Motion to accept.
Move to accept.
We have a motion and a second. Any other questions? All those in favor signify by saying aye.
Aye.
Any opposed? Thank you. Next up is a discussion I wanted to have on a potential solution to a challenge we're having in maintaining both the courthouse and the Judicial Center. I've been working with Charlie Ransom, our maintenance director, and the Judicial Center, as many of you may know, is quite a challenge to maintain, both in small ways and in large. And part of the struggle there is that we also have responsibility for this building. Charlie maintains this building. He has an assistant that comes in at 4 o'clock to help monitor the cleaning service personnel that clean both the Judicial Center and the courthouse, and that takes up most of his duties in the evening. He's able to help on some things that require attention, fixes, things like that, but not always. And as I mentioned, the Judicial Center is an ongoing elephant to wrestle. So in talking to Mr. Ransom about this, I mentioned that next year's budget, I might hope to to devote somebody to that building, and Charlie took it upon himself to research this a bit, and he's been able to get confirmation, written confirmation, from the administrative office of the courts, which funds many of the the maintenance projects over there. Written confirmation that a part-time devoted maintenance person is covered under their payments, the things that they are eligible to pay for. And he said because of that, we could start the idea of a part-time person devoted to maintaining that building right away if we chose to. And the discussion I want to have is, how do you feel about doing this in Charlie's plan from 12 to 4, noon to 4, which would, this would be a third maintenance person. Charlie's full-time, his current part-timer, and then a third person at part-time. And his or her job would be from noon to 4 o'clock taking care of the maintenance center. Not overseeing Francis employees, not worrying about what has to happen here, but devoted to the judicial center. Charles Ransom would continue to be the 8 a.m. to noon go-to person for maintenance duties, including at the judicial center. But then he would have this help paid for by AOC to make sure that we keep the judicial center in good running order. Reminding everybody that eventually we're going to inherit that building, and the better job we can do maintaining it now means the better shape it'll be in when we finally take full possession. Again, we have 20-hour-a-week, $11 an hour salary is what Charlie's proposing as a schedule and a salary. And he has a series of responsibilities, and I can read them to you real quick. This is the kind of work this person would do: maintain building inside and out, change lights, adjust flags, the flagpole, clean out flower beds, empty smoke bins, check recycle bins, clean up spills, unlock doors, lock doors, some mowing. That's the kind of continuous stuff that takes up Charlie's time over there, in addition to the big things that happen, obviously. We've had challenges with the heating and air, plumbing, for example. I'm going to open it up to any questions or discussion. We're not going to take care of this today. We're going to wait till, if you're amenable to this, identify a potential candidate, and then bring back a resolution adding this position and noting that AOC will refund the cost of this person. We'll do that at a later date, but I just wanted to run this by you today to see what your thoughts are.
I'm for it myself, and of course I thought the judges were supposed to be.
Microphone? Yeah.
But the way they've got things set up, every now and then you'll notice an odor, and what that means is the water has evaporated out of the traps, because there's no, the way they've set it up when the building was designed, there's no water going into some of these things, but yet they've got drains, and when the water gets out of the trap, well, the sewer gases come back up in the building, and so somebody's got to run get a pitcher. I mean, there's a multitude of things that have to be done on that building. It's constant. If somebody spills something, and we do have a lot of traffic in and out of that building, somebody spills a drink in court, somebody's got to get it and clean it up.
And that constantly distracts whatever projects we've got going on here or out in front. It is a constant challenge.
I hope they're changing. I think, aren't we changing some of the lights out too?
Yes.
Because they I forget what kind of lights they were, but each one of the bulbs cost like $19. I mean, it was, and they only lasted like a year. You look up in the courtroom, and there's always 4 or 5 of them out. And
we're switching to LED at the moment.
Yeah, so.
Yeah. But again, that's another project that takes time. And anybody, so, and you didn't have your mic on, but Magistrate McCollum mentioned he supports this idea. Any other thoughts? Again, if not for the AOC's willingness to cover the cost, I would have waited until next budget session to bring this up. But it's nice to know with AOC's written approval, we can begin as soon as you feel it's appropriate.
How soon do we do that, Judge? I mean,
I can as soon as Charlie comes up with a good candidate that he's willing to hire, I'd bring it back to court.
I think it's a good idea. There's a lot of work over there, no doubt.
Eventually, I'm sorry. When we take ownership of the building, we'll have a lease back to them, and we'll have to do it now. Now, what they did when they had this building, they leased it, and the starting rent is based upon what it costs you per square foot to build it, and they'll do the same thing too. So they're all not all that benevolent as far as that. I mean, and that was a very cheap judicial center, comparatively speaking, to any place else that I know of. That was $9 million. I think Hancock County was 18 or 19 million. I mean, but it was that way because that's the way Gross Lindsay wanted it. He wanted it to be a bare bones type. Some of the other ones have mahogany and cherry. We got plywood covered with something veneer. And yeah, stuff like that. So, but it was. We're not going to get rich off of leasing that to AOC later either. So.
Just hope to cover expenses.
Exactly.
So, with your permission, we will continue the work of identifying a candidate and bringing that back to fiscal court, correct?
Yes.
Okay. Thank you, and we will begin that work. Mr. Gold, your report.
Judge, I've got a check to turn over today, but one thing that I would like to do is I would like to recognize Kyle Evans, our first assistant county attorney. He was last week honored by the Kentucky Cabinet for Health and Family Services as being the top child support attorney in the state. There were a couple hundred attorneys in the state up for this, and what he does in order to do that as doing that as part of his duties. I mean, you also see him at all the county things here that go on. The fact that he is able to get that done and to have received that honor against folks in Louisville and Lexington that all day, every day they're doing child support is a real testament to the kind of guy he is and the fact that he's willing to put in incredibly long hours to get the job done no matter what it is. And I'm really proud to work with Kyle. I think we're lucky to have him, and really proud of the fact that he has received that award and is very, very well deserved. So I just want to take a moment to acknowledge that and tell him congratulations publicly.
He's worked so hard. He's about to go on the disabled list, I notice, with an injury. Had to be the wrestling back and forth of Field and Main, right? I mean, you got so dug in, it ended up in a...
He's made a few jokes about my hard head, too, that as well. But as far as checks, Judge, we only have one check today. That is $639.91 in jail fees collected, bringing the fiscal year total to date to $54,568.63 turned over to the county from the county attorney's office.
Motion to accept.
Second.
A motion and a second. Any other questions? All those in favor
Steve,
signify by saying aye.
I have a question
Oh.
for Steve. Steve, on these jail fees,
Yes, sir.
what do we do when we get people who are not paying? Because I know they get out and they owe, and it'd be foolish to put them back in if they already owe.
Exactly. That's the classic rock and hard place there is, the last thing you want to do is turn around and put them right back in because that's just going to cost the county, and you don't want to criminalize somebody being poor.
Right.
So what we do is we try to work with people as much as we can, set up reasonable payments. Of course, there's some people that have been in there for a good amount of time, and they come out with what they feel are insurmountable amounts. We have some people paying us, $5 a week, $5 a month, something like that. We try to work with them. The fiscal court has passed that per diem amount, and it is about taking some amount of personal responsibility, which is an important thing. So it is. There's that is a fine line that we try to walk. So the last thing that we try to do is ever put somebody back in for not paying the jail fees. That threat is there, and that is something that could ultimately happen. But that is what I would consider a nuclear option, and it just doesn't happen very often. It has happened years ago, but as far as I know, it's been a very long time since that's actually occurred. So it's it's a very difficult thing. There is, the jailer through the commissary accounts does have some means of collecting some of that while somebody is in, while they're putting money on their books and things like that. But once they're out, it's Rebecca Hine in our office works with people and just tries to track them down. A lot of times they're coming into the office anyway because they may be either paying child support or bad checks or, what have you. And so we're able to, talk to them about that then. But we try to work out, very favorable options for them just because we do want them to be successful and not, grind them down to where they feel like they, are in such a hole that they can't get out of it.
So do we have anything like a, better words, work program to where they could volunteer and work some of that off, or?
That's an interesting idea, and it has been discussed in the past. There are some liability issues that come up with that. But I do think it's something worth exploring, and Jailer Brady and I have discussed that in the past about how we could leverage that to where we could have people still be responsible for at least partially defraying some of the cost of
Right.
their own incarceration. But it's a tough thing to do because, you put somebody out on like if they're mowing or something like that, there's liability involved there. So something certainly open to, and I think does merit further discussion.
You also run into Social Security issues, unemployment. I mean, you got some other issues
Right.
there too that make it difficult. It's really hard money to collect. So
So we have a motion and a second. Any other questions? All those in favor signify by saying aye.
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 Any opposed? Motion carries. Treasurer Brenda Ryder would come on up. She has a fund transfer, and I'd like to explain it because it was basically my error. When we were discussing budgeting for Randy Tassa, you remember we wanted him to replace his vehicle. He'd had I believe, a Ford Escape or something along those lines. It had over 200,000 miles, and it was becoming unsafe for him to go to conferences out in the state. So we agreed to get him a new vehicle on state contract. I budgeted in $28,000, and I undershot it. The actual price, even buying it on state contract, was $37,855. And so to make that up, I have asked Treasurer Brenda Ryder to propose a $10,000 transfer from contingent appropriations to the building inspector supplies, which is where we budgeted for the vehicle. $10,000 because that would cover the sticker price of the vehicle and leave Mr. Tassa a couple $1,000s in for actual other normal supplies, because otherwise we'd be cleaning out that line item for him and he wouldn't have any money to buy just the normal stuff. So that's what this transfer is all about. If you need to add to that at all, Treasurer Ryder. Any questions about that? Again, this was my understatement or poor guess on the cost of this vehicle.
This is an appropriation transfer within the existing budget, and it is just moving an appropriation from one line to another.
Yeah, and that's what the contingent appropriations line item is for. These unexpected expenses. Any other questions about that? With that, I'll entertain a motion to approve the transfer.
So moved.
We have a motion and a second. Any other questions? All those in favor signify by saying aye.
Aye.
Any opposed? Okay. And you have some claims?
Yes. I have 3 claims from the general fund. The first one to Paul Miller Ford in the amount of $34,010. This is for the EMA vehicle, which was budgeted and is to come from the EMA supplies appropriation line.
And I'll note that we did get that estimate correct.
Yes.
Thanks. So I was 1 for 2. Not too bad.
The second claim from the general fund to Paul Miller Ford in the amount of $31,844. This is for the building inspector's vehicle. Third, from the general fund in the amount of $2,213.80 to Visa. This is for judge office supplies, judge training and travel, and fiscal court training appropriation lines.
Any questions about those claims? All those in favor signify by saying aye.
Do you need a motion?
Oh, I'm sorry. Motion. I've been jumping the gun all week.
So moved.
Second.
Motion is second. Okay, there we go. All those in favor signify by saying aye.
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 Any opposed? Thank you. Now, for good of the county, we have a budget amendment that has come up, and I want to explain it a little bit. You have, hopefully you have in your packet a copy of the amendment proposal. There are two things here. First, in dealing with the flooding earlier this year, Bill has spent quite an amount of his rock on re-rocking those roads and fixing them and waiting for FEMA to reimburse us on those costs. We're pretty confident that either before the end of this fiscal year or hopefully at least next fiscal year we'll get those reimbursements. FEMA is an unusual bureaucracy to deal with, but in the meantime we need more rock. And Bill is asking for about $400,000 in rock to continue to do our normal maintenance and construction activities. The road department has its own reserve. It's leftover surplus after his expenses and revenue are taken into account. It's a little over $1 million. And what we're proposing here is to use $400,000 of that in reserve, transfer it in, amend it into the budget, and allow Bill to spend it on rock and be reimbursed eventually by FEMA funding. Is that fair to characterize, Mr. Hubiak? Yes, sir. So we all know that's necessary, and hopefully we'll get a lot more back from FEMA than $400,000. But that's the first of the amendments. The second amendment has to do with the grade all. And with that, I'd like Mr. Hubiak to come up and explain to the court why we're needing to amend in $95,000 for the first payment on the grade all lease and why it's not already in the budget.
This basically was an error in my part on the budgeting of our new equipment. We didn't take into consideration in the lease payment that we were going not to trade in a grade all as we did 3 years ago. The reason being is those members that are on the road department committee is we have put so much money in the repairs of the second grade all that we didn't think it would be economically viable to trade that piece of equipment in because it would be worth far more than what they would give us on a trade-in. Therefore, we decided to keep the third one because that keeps us in operation when one is being down for maintenance or repairs. Along with that, that was, I think, the last grade all trade-in, we got $50,000. So of the 95, plus there was I believe, about a 15% increase over the price of the grade all that there was that we purchased 3 years ago. And that was over 3 years, about a 5% increase each year, which made up close to the difference.
So, some extenuating circumstances, I'd say. And as Bill pointed out, this leaves us with 3 grade alls and not just 2,
right,
even though one is 3 years used. To the point of Mr. McCullum and Mr. Southard, having an extra grade all is probably a good thing at this point.
I'm not in the business of normally keeping spares, but in this case, it makes economic sense for the county because of the amount of money that we've had to expend keeping them up because we're out of our sequence of trading in and acquiring new equipment. So,
but still hoping to make it all work, both in the value of the machinery and utilizing it for helping our roads and other projects.
Bill, I appreciate what you do, trying to organize it that way. I know you got out of sync because we didn't have money a couple of years ago, and it is. I appreciate getting us back to where we are. And when did that check recently come in from FEMA? What year did that come from?
We have been receiving some of the checks on, this is, the rock expenditures were from the 2018 flood occurrence. We have been receiving some of the funding over the last year. With the first one, we received $51,000 in February, $102 in April and March, $73,000. June we got $114,000, and then in July we got $59,000. Now this is not all of the money. The actual monies that we've been approved for and appropriated is much more than that. But these are small projects that they have reimbursed us for today. So it's ongoing. We don't know when it comes in, but we have to expend it or we don't get it. And the county's portion of close to, I believe, Kirk, the number was almost $1 million, is 13% that we got to put in. And then of that, then the state is required to give us 12%, and the federal government gives us 75%. But you've got to spend it to get it back, and that's the way the process works. And unfortunately, we have no clue to when we get the money back at different times. We received a check here this last month from an event that occurred in 2011. I mean, it's unfortunate. It is very hard for us to budget for things like this, but if you don't spend it, you will never receive it back. So
I'm sure they're paying interest on that, right?
yeah. Good point. Yeah.
They are, but just really small.
Yeah.
Yeah.
I think the better way to say it is they're somewhat interested in paying us back.
Yeah.
So hence the need for the $400,000. And Bill explained the need for the 95. Again, this is coming out of road department surplus carryover from last year. It doesn't impact the general fund carryover. Since we have that available to us, even though we always like to try to stay within budget, but again, a couple of these two things are a bit of a anomaly. So with that, I'd like to just gauge your willingness to go ahead and make these expenditures, to let Bill keep doing what he's doing. And we can read the ordinance here in a bit. But any other thoughts about this? Again, we always try to budget correctly, but some things are hard to divine ahead of time. With that, I'll have the clerk read the amendment.
An ordinance relating to the annual budget and amendment thereof, whereas the County of Henderson has realized unbudgeted receipts from prior carryover road fund to meet additional appropriations required for rock materials, FEMA reimbursable flood repairs, and road debt service, which is the Grade All monthly lease payments from October 2019 to June 2020. Be it ordained by the Fiscal Court of the County of Henderson, Commonwealth of Kentucky, the budget for fiscal year 2019-2020 is amended to increase the receipts of the prior year carryover road fund by $495,000 to include unbudgeted receipts from account code 02-4901, it's a prior year carryover, by $495,000, and increase the expenditure account number 02-6105-409, which is rock materials, by $400,000, and account number 02-6105-602, road debt service, by $95,000. The amounts suggested in the receipt and expenditures in Section 1 are for governmental purposes.
And before we vote, we will promise that next year we will budget in the $95,000 debt service into the normal budget.
It will be more than that because we're 3 months short.
Whatever the debt payment is, we'll make sure to budget that then. Any other questions?
Just a quick question, Judge. I know in the road department budget there was new machinery / equipment. There was a line item for that had about $358,000 in it. Was that anticipating the purchase of a Great All, or was that other equipment that was purchased?
That's other equipment, and we'll just leave it like it is for right now so she doesn't have to make any other changes.
And the two major pieces of equipment contemplated in that line item were a truck cat Is that right?
Dump truck.
And a dump truck, yeah.
Okay, I just, want to make clear that there was the need for this, okay.
My pleasure to make a motion to approve.
Second.
We have a motion and a second. Any other questions of Mr. Hubiak? All those in favor signify by saying aye.
Aye.
Any opposed? Thank you for your patience on that. This time, anybody who would like to come up and speak for good of the county? Sheriff Brady?
Thank you, Judge. I think most of you are aware of the situation last Friday where there was a police pursuit coming into Henderson off the Audubon Parkway, and a pursuit ran on Highway 1078 through Zion and then Highway 351 and was heading into town. Kentucky State Police, and I think maybe the DEA, was involved in the pursuit of a felony drug person. Deputy Aaron Daniels of the Henderson County Sheriff's Department was in the general vicinity, and due to the speed of the pursuit and the unpredictability of what direction was going to take, his intention was to get in front of the pursuit, put out stop sticks, and stop the pursuit before it got to town. Unfortunately, the pursuit got there before he could get stop sticks out, so his intention became stay in front of the pursuit, slow the vehicle down, and stop it before it got to the East Heights, Henderson County High School, North Middle School school zones, 3 o'clock in the afternoon. So we got a bunch of kids out there, a bunch of school buses, a bunch of cars. The car came over the hill, intentionally rammed into the back of Deputy Daniels' vehicle, doing major damage. They tried to come around him to the left. Deputy Daniels swerved to the left, knocked it off the road. Pursuit was over with. Literally within 100 yards of the East Heights school zone. And he expressed to me out at the scene that day, he said, my intention was to stop the pursuit before it got to the kids. I think he did extremely well under trying circumstances. It was split-second decisions. He put himself in harm's way. He placed himself between the pursuit and our school kids. I just wanted you all to know how much I appreciate our people that are willing to do those things. Hopefully we will more formally recognize him in a court meeting in the next couple of weeks, maybe with a resolution or something. But 3 o'clock last Friday could have been a disaster in our community that we would have a difficult time getting beyond for a long time. I'm just really proud of him placing himself in front of those kids. So I want to make you aware of it, let you know how proud we are of him. I know you feel the same way. And hopefully in the next few weeks we'll do a resolution or something to formally recognize him. Thank you.
I'm really glad you said that because that was the plan, at least a commendation.
Yes.
And I meant to talk to Deputy Daniels personally. He's been on third shift, if I'm not mistaken, recently. Hard to catch him.
He's uninjured. DEA made their arrest. Nobody got hurt.
Excellent. That's always the goal. Thank you, Sheriff. Anybody else like to speak for good of the county? Magistrate Southern.
I'd like to say the roads in my district are looking very good. I appreciate what y'all do. It's not easy to make gravel roads stay good. And all's good in our district. Thank you.
Magistrate Moran.
I agree. That the road department, we have a wonderful department that takes care of all of our budgets. I appreciate all these people, and they keep us informed, and I really appreciate that. And all's good in the second district.
Magistrate McCollum.
All the roads in my district are in really good shape. I would like to commend Kyle and congratulate you on your award. It's well deserved. And I think because of Steve and Kyle, Henderson is one of the few counties that is not going down in child support collection. And I think that's one of the real reasons is because of Kyle and their dedication to it. I think the state, once again, I keep harping on it, but the state has let us down. They have not funded the county attorney's office for the collection like they agreed they were going to do back in the 1990s when they took away the incentive money from the county attorney's offices. And they've just done an outstanding job, whereas other counties are not doing that. So it is a hardship because now we're subsidizing that, but it's well worth us doing that. But all's well in the fifth.
Thank you. Magistrate Berry.
Thanks, Kyle. Congratulate you and Brian for being here. Well, Claudia too. She's here. We have to recognize her. And Bill Hubiak, good job. Bill can take a nickel and make it into $1. Seems like you do a good job. Appreciate that. And Bill Stevens, glad to see you here. And Sheriff, I saw that car, and it was a miracle nobody got hurt. Anytime there's a pursuit, whether it's a wreck or not, the potential is really high for somebody to get hurt, and that's why I never liked those things. But he done a good job. Thank you. Everything's good.
Mr. Gold?
Judge, I already feel like I've done too much talking at this meeting. Seems like everything I've had to do some amount of talking about. But I do want to recognize Brian Bishop for his non-planning commission duties. This past weekend, he spearheaded the Henderson Wiffle Ball Classic for the benefit of the Boys and Girls Club out at the Henderson County Fairgrounds, and raised over $6,000, pushing $7,000 at this point, for the Boys and Girls Club, with an event that was just a ton of fun. And want to recognize that. And that's one thing, if you look at it from Sheriff's Department, Treasurer's Office, if you look around at county employees, Road Department, every department we've got, there are people involved in this community in ways outside their public service, and that's something that I think is really important. We have a lot of people that they have servants' hearts. They're serving during their 9 to 5 or 8 to 5 or second shift at the jail or what have you. They're doing that serving, but they're also going out and serving when they have their time off, and they're serving our community. And I think that's something that is really important, and we're very blessed to have employees that do that. And Brian is just the most recent example of that, and I want to thank him for that and recognize the fact that he and his crew that put that together created something out of nothing. And he got Independence Bank, Field and Main Bank, and German American Bank to all be part of the same event, which that in and of itself, getting the banks to come together and unite around something is really, that's not an insignificant thing. And the children of Henderson are better off for his and his team's efforts. So thank you for that. And I want to echo what was said about Deputy Daniels. Also speaks to the character of employees that this county has. We've got people that are willing to put themselves on the line and put themselves in harm's way to serve this county. So I just I'm proud to be among them, and proud to be the county attorney. Otherwise, all is good at the office, Judge.
Thank you. To continue with the praise of Deputy Daniels, people don't realize, or they may not realize, how dangerous that really could have been, and he took the initiative to adapt and overcome and make that situation go away, and we really appreciate that. I appreciate all the sheriff's deputies and their department. This morning out in the parking lot, as we walked in, a local grandmother had accidentally locked her baby in her vehicle, and she was distraught, as you can imagine. Wasn't hot yet outside, but it was getting that way, and Terry Harmon was able to quickly respond to our call, because we know he is an expert in all things automobiles, and he was able to get there in about 8 minutes and open up that car. We were joking that in a former life he must have been a car thief, because he got into it very quickly, and if you can imagine the relief on the part of this grandmother getting her 1-year-old out of that car and looking at Deputy Harmon like he was an absolute savior. It made me proud, and it also made me thankful that we have a cooperative team, because Rick Burleson down in the bad check division, I forget, what's his assignment now?
Ron Burleson. He's
Ron Burleson, I'm sorry.
Does our prosecution work.
Ron Burleson was quickly able to get to the sheriff's department to see if there was anybody handy, and they made the call to Terry Harmon, and we got Terry Harmon here, and all's well. I'd love to see those things, and always have happy endings. I also want to piggyback on what Mr. Gold said about our community. There's no doubt that our county employees help in many facets, and congratulations again to Brian Bishop for a successful first-time fundraiser. It's always kind of anxious to see how the community is going to receive those things, but this one was a hit, literally a hit. And it reminded me that some folks who say nothing ever happens in this town are simply not paying attention. And this time of year especially, when there are multiple fun fundraisers that not only help organizations but also give local folks something interesting to do and hang out and get together, utilizing both downtown and the fairgrounds. And just in the last week and a half, fundraisers for the Boys and Girls Club, Healing Rains, several other nonprofits, and again with events that are enjoyable and fun. And I think it speaks not only to our willingness to try to get people together and have a good time, but the generosity of the community, always turning out seemingly for these events. So proud of Henderson County and proud of the people. Yes.
Hey, Beth, I think the pun he meant to make was it was a home run.
For the record, I'll say it should have been a home run. It was a home run. And the only reason he said that is for me to admit that he did hit some home runs. I think they
moved the fence
in. Yeah. I want to commend our schools. The Kentucky Department of Education just put out rankings, developed a ranking system, just released those. Henderson County High School was in the top 44 in our state according to this ranking system. South Middle School was top 25. Always good to see people who challenge the quality of our local schools and the progress they're making. Need to look at those rankings, and I posted them on Facebook this morning. I encourage you to check those out and compare our high school ranking versus many others in Western Kentucky. One of the top ranked high schools in Western Kentucky, and certainly one of the top ranked middle schools. We instituted a burn ban earlier this week, and asked a couple times why it took us so long when other counties had instituted a burn ban last week. The reason is because burn bans are serious, and it's an enforcement issue, obviously. Burn bans without significant enforcement mean nothing. And so to go ahead and take the step of instituting a burn ban with some follow-up intended is not a light measure, because it impacts a lot of community activities and plans. So we wanted to wait until there was absolutely no doubt that a burn ban was necessary before we declared one. And we did. But for those of you who are wanting to know why we didn't do it immediately, any knee-jerk reaction to imposing bans like that or emergency declarations, you need to be careful with those, and that was my consideration. And after talking with many people over the weekend, we came to the conclusion we did, but just wanted to clarify that. With that, I will entertain a motion to adjourn.
I'd like to make one more statement. I'd like to commend our county judge and our county attorney. Every one of the fundraisers I was at, they were there too. And they're not cheap, but they were a lot of fun. And I commend both of you guys. And I'd make a motion to adjourn.
A motion, a second. All those in favor can leave.